With me now to give us the bottom line, as usual, is Paul Henderson, BNC's legal contributor, veteran prosecutor, and director of the Department of Police Accountability for the city of San Francisco. All right, so Paul, there might be some confusion with regards to what this Colorado law that was just passed is, what it entails from a state level, federal level, and then you have this policing act that is still being held up from being passed, and what that could mean for other states. So please break it down as best as you can, and I know you can, for our viewers.
Okay, here's how it works. So here's the thing with qualified immunity. It just came up from the Supreme Court in 1967. And basically the theory behind it was that you can't be sued as a police officer or a law enforcement official if you are acting in good faith and if you didn't know that the act that you were engaged in was illegal. And that covered all governmental agencies. It's been expanded over the years to act as a shield specifically with law enforcement officials and actors, so that now, even if officers knowingly violate someone's rights, they are protected unless a previous court has identified that that act was ruled unconstitutional and executed in a way, pun intended, executed in a way that was similar to a previous ruling in a court. That's acted as a huge shield. And so what has happened now is that states are taking their own action to address qualified immunity and remove some of those protections specifically for law enforcement actors. That's the issue. What Colorado has done is taken up the action specifically because there's been a vacuum and none of that action had taken place at the federal level before. So even though the JIPA bill, the Justice and Policing Act, which is now the George Floyd Act, is pending, it hasn't happened yet, and it is at a federal level, which preempts state action. So states independently are taking action like Colorado, and that's why it's so groundbreaking. And what they're saying is that they will define liability or open up civil liability at a state level for transgressions involving law enforcement related government workers. And all of the other government workers are still under those federal protections and state protections. There's a little bit of a carve out. That's why this is groundbreaking. The other thing to point out that makes this such a big deal is that Colorado has included in their bill reforms for use of force as well. So carotid techniques, which are neck restraint techniques, are also included in the bill and are removed. That's a big deal because even though we've talked about a lot over the past few months, use of force with George Floyd, 2/3 of most law enforcement agencies have not reformed their use of force policies. And that means by adoptive admission, they're still engaged in non-best practices like no-knock warrants, the Breonna Taylor, shooting at cars, carotid restraints. It's a big deal now that states are taking this action, and Colorado, I believe, is going to lead the way to what other states can do.
Well, Paul, address the argument that some folks like to make. Well, actually, before I get to that, let's listen to a clip from Representative Jimenez, and he lays out the argument in opposition of getting rid of qualified immunity.
In this dysfunctional Congress, we got a bill that strips our frontline police officers from qualified immunity that will weaken and possibly destroy our community's police forces. As mayor and sheriff of Miami-Dade County and a former SWAT medic myself, I was actually responsible for ensuring my community was kept safe from lawlessness. I understand firsthand the importance of qualified immunity for police officers to carry out their jobs. Officers perform vital tasks requiring split-second decisions under intense circumstances.
All right, Paul. So basically what he's saying is limiting qualified immunity is going to make it harder for police officers to do their job. What say you?
And the opposite argument of that is not limiting it has opened the door and institutionalized race disparate policing. Now, those are just facts. And so that's where we are today, and we have to address it and we have to deal with it. And this is only one of the tools that we are currently using in this society to address some of the shields and blocks that we've had to address transgressions that have previously gone unresponded to from the court system. This is something that, the Supreme Court, because they created qualified immunity, could undo it. And they've had no less than 8 opportunities in this last cycle to pick up a case to redefine it, and they have not. And so it's created this vacuum at the state level. That's why we're seeing this action here and now. But the back end of that argument is obviously officers and many of the police unions are against all of this because they certainly don't want personal liability for transgressions or to be appearing in court and being sued for their own behavior. But that's why we're having this conversation now.